Welcome to the EFC webinar on Unpacking the Trinity Western University Supreme Court decision. My name is Karen Stiller. We are very happy that you're with us today. Today is primarily about answering your questions. We have three experts on hand for you. Our three guests are Bruce Clemenger, President of the Evangelical Fellowship of Canada, Albertos Polizogopoulos, an Ottawa-based lawyer who appeared in the Supreme Court with this case on behalf of the EFC and Christian Higher Education Canada. We also have Justin Cooper with us, who is Executive Director of CHEC. I'm going to ask our three guests to start by giving brief opening comments on the decision as it relates to their areas of expertise. And then we're going to start fielding your questions, which you can send in via the chat function on the side of your screen, which you should see. We've also been receiving your questions all week through social media, and we have some of those on hand as well. So let's get started. Alberto?
Thanks, Karen. I'll be as brief as I can be. The decision is actually two decisions, one coming out of the Ontario Law Society's decision to reject Trinity Western's application for accreditation, and the second coming out of BC's, the BC Law Society's decision. So what was interesting was in Ontario, Trinity Western had lost all the way through up to the Supreme Court, but in BC, they had been successful all the way through up to the Supreme Court. And then ultimately, a week and a half ago, the Supreme Court ruled against Trinity Western in favor of both law societies. The effect of that is that Trinity Western doesn't get to start its law school except or unless it amends or gets rid of its community covenant, which includes, among other things, a commitment that all students will not engage in sexual intimacy outside of the confines of a biblical marriage between one man and one woman. So that's the effect of the decision. Obviously, it's a 200-page decision, and it's got really far reaching implications from the legal perspective, and particularly with respect to religious organizations and institutions. What I will say is the reason, if we were to try and really get to why Trinity Western lost in one or two sentences, the court's rationale was that the law societies were created by their provincial legislatures, to regulate the practice of law, but they each had an overriding legislative requirement to protect the public interest. And both of those law societies interpreted that mandate as ensuring equal access to the profession of law. And so the court found that since they had that overriding mandate of protecting the public interest, and since they both interpreted the protection of the public interest to include equal access to the profession of law or the study of law, it was a reasonable decision because the law societies had two options. They either accredit the Trinity Western Law School or they don't accredit Trinity Western Law School. And in that scenario where they only had two options, the Supreme Court found that it was reasonable to not accredit the law school, even though that resulted in a violation of the religious freedom of the Trinity Western community. And one of the reasons they found that was a reasonable way to go about this was because they found as a court that nobody at Trinity Western attended Trinity Western because they had a religious obligation to. Rather, they wanted to study law in a Christian environment because they thought it would be favorable or better for their spiritual development, but not required. So the Supreme Court found that studying law in a Christian university, in a Christian environment where there is a community covenant and where like-minded individuals agree to live in a certain manner was not necessary and integral to the practicing of faith of Trinity Western students. So they found that this decision, while it did impede the religious freedom of the Trinity Western community, it didn't result in Christians not being able to practice law or study law. It simply meant they can't do it at that institution. So that's kind of the simplified way of explaining what the court did and why they did it. And I suspect we'll be talking about some of the major implications that might come from it later on.
Thank you. Over to you, Bruce.
Building on Alberto's comments, it was a very focused decision. It was about Trinity Western's law school, whether it be accredited. It was acknowledged that what Trinity Western is doing by having a covenant is not unlawful. It's consistent with provincial human rights codes. There's nothing unconstitutional about what Trinity Western was doing. And also, again, as Albertos mentioned, that the test was whether the decision not to accredit was reasonable. So in my mind, Albertos can correct me, but if you understand the context, when Trinity Western first broached the idea of having a law school, the Federation of Law Societies of Canada actually approved the idea. And they thought that the primary interest of the Law Society would be, will Trinity Western be able to produce well-qualified and trained lawyers academically? And the Federation thought that they could. And so they had approved it. Then you had 3 law societies that dissented, and 2 of them ended up all the way to the Supreme Court. So while what they did was the court interpreted them reasonable, given the options they had, as Albertos mentioned, they didn't say that it was the Federation Law Society must change its decision, or we don't. If Trinity Western decided to put a law school in Alberta or Saskatchewan or a province that didn't object, then it may be also reasonable to accredit the law school. Next one would be context. This is in the context of, I think, a couple other cases that are pertinent. One is the Wall case. Just a few weeks before Trinity Western's decision, we had a decision from the Supreme Court, 9-0, which basically affirmed the idea that courts have really no jurisdiction or competence in looking at the internal affairs of churches, particularly issues concerning theology, membership, discipline. And so we need to understand this in context. And also, of course, there's the whole Canada Summer Jobs issue that's surrounding us, which is a different issue. But I think also often people, when they're asking questions, they're looking at Canada Summer Jobs, looking at Trinity Western, and bringing them together. The last thing I'll say is that, ministry in Canada is challenging, and it's getting more complicated. But as I said, and is actually the one of the problems for facing Trinity Western was, as Albertus mentioned, they required a covenant in terms of people behaving a certain way. They didn't require adherence to a statement of faith, and they actually did that to advance their purpose. They wanted to be, in a sense, as inclusive as possible. So not let belief be a barrier, but to maintain the mandate of the institution. They wanted people to agree to live a certain way together, to form community in a certain way so they could advance the purpose of Trinity Western. So it's actually the desire to be as inclusive as possible that actually caused the problem, because the Supreme Court noticed that division between covenant and not requiring a statement of faith, and whether that had an unintended consequence from Trinity Western's mind that the Law Societies found problematic. So I'll end there.
Okay, Justin, speak to us from the perspective of Christian higher education in Canada.
Well, again, building on the, am I need to unmute?
Yeah, no, you're good. We can hear you.
Okay, good, thanks. Building on this idea that the decision is a focused decision, I think that for Christian higher education, the question next is the BC College of Teachers. Are they going to in some way try to build on this decision and copy it? And here I think we need to remember, as Bruce said, that the 2001 decision has not been stricken, and so it stands. Also, there's not, I think, a very direct legal link between the special treatment of law societies versus teacher education. But if this were, and Trinity Western may change its covenant and somehow to mute this conflict. If the teachers were to be successful, there are 6 other Christian faculties of ed across Canada. They're in 4 different provinces. And so we could see something like that get larger. But as far as professional accreditation goes, the only other area where, besides law and education, that really has been militant is social work, and they had inclusive accreditation standards already in the 90s. So moving on to students, I think this decision could embolden a disgruntled student to say, I'm going to challenge my community standards in my institution as discriminatory. And so perhaps a couple of institutions have had near misses with students going to human rights tribunals. This may bring that back on the table. With respect to funding, that's already been touched on, and I'm happy to read this morning that Trudeau's summer grant initiative is being challenged legally. Let's hope that goes well. If it didn't, it is theoretically possible that some provinces might decide to take the same approach with respect to student aid and say, you want student aid, you need to check the box. And student aid from federal and provincial sources is a large source of funding for Christian higher education institutions. But again, here, I think that an Ontario government under Ford, an Alberta government under Kenny, a national government under Andrew Scheer would look very different than what we're seeing now. And then let me end with this. I think, as has already been mentioned, there are a number of Christian higher education institutions that do practice open admission, but have community standards. Is this an opportunity to look at best practices for community standards so that they are effective in maintaining a campus ethos, applied pastorally and not legalistically when it comes to individuals? I'll stop there.
Okay, thank you, Justin. You guys seem really calm, which is great. But my take on the initial response to this decision was, people were really concerned and upset and alarmed at the hit to religious freedom in Canada. So I'd like to just talk about that for a moment. And Alberto, maybe you can begin. Like, how serious a blow is this to religious freedom?
So that's a pretty loaded question, Karen, but it is a blow. So we're calm, but we've had some time to digest it. There's no doubt this is a blow. There's no doubt this is a setback. There's no doubt that it was devastating and discouraging. But contrary to what some of the writings that have been getting published are saying, this is not the end of religious freedom in Canada. The Supreme Court did not gut the Charter of Religious Freedom. As Bruce mentioned, this is a very specific and a very focused decision. And in fact, I don't want to get too technical here, but there are two analytical frameworks that courts will engage in when there are charter rights being evaluated. And there's a rigid analytical framework and there's a fluid analytical framework. And the court in this case said, we are going to affirm this fluid analytical framework for these kinds of decisions. People who like charter rights, they don't like this fluid analytical framework because what you have is you have a law society in BC and a law society in Ontario making the same decision, all of which are getting challenged, and the court saying one is reasonable and one is not reasonable. So people who like charter rights don't like this fluid analytical framework. What's good from this decision is that 4 of the 9 judges attacked that analytical framework and said this fluid one doesn't work, we need to reevaluate it, and it's problematic. So that's a good sign. But what's also good is that because the court relied on this more fluid analytical framework, or what is called the reasonableness standard, that means it's not a binding precedent in all instances. So the first Trinity Western case was before the development of this more fluid analytical framework, which is why we all said this is a binding precedent. The reason the courts here below didn't rely on the first Trinity Western was because the analytical framework changed. So long-winded way, as lawyers generally do, of saying we're calm because we appreciate and we recognize that although this is really discouraging and in some ways devastating, it's not the end of the world as we know it. In fact, it's a signal that this is a decision that is very specific to this set of facts and this legislation that was being considered. And it's also a hint that this may be the beginning of the end of that more fluid analytical framework, which I think would bode well for not just religious freedom, but all charter rights.
Okay, Alberto, you were actually in the courtroom. You were arguing as an intervener. Were you surprised when the decision came down? Did you have a gut feeling as you were waiting for it?
Well, I obviously had everybody had their own predictions. I had mine. I thought we would be successful. I thought if we did lose, it would be much more narrow. It wouldn't be 7-2, it would be 5-4. So I called it wrong, as many of us did. What was more surprising was not that we lost, but that the 2 concurring judges, so the previous Chief Justice McLaughlin and Justice Rowe, really appeared to be on side during the hearing. They really appeared to be in favor of giving Trinity Western the win. In fact, in the first Trinity Western case, Chief Justice McLaughlin had sided with Trinity Western. So that was more surprising than the loss, I would think. Yeah, so I called it wrong, just like many people called it wrong, but frankly, I never call it right, unfortunately.
Bruce, how about you? Your take on this in terms of a religious freedom hit? You're hearing from the evangelical community across Canada, I'm sure. What are people feeling, and what are you thinking about that?
Two responses. One, it was a hit, and deeply disappointing. Again, imagine Trinity Western. This has been a dream they've been building towards for years and years and years. Put a lot of time and energy into it. As I said, the Federation of Law Societies had signed off. The BC government had actually granted approval, which they withdrew when the BC Law Society objected. But even then, the BC Law Society, they had engaged their kind of board, they called them benchers, had sought legal opinions, and a lot of the legal opinions leading into their, this decision of the Federation of Law Societies and others confirmed that Trinity Western was on solid ground. And so that you had competing courts of appeal. You had a Court of Appeal in Nova Scotia that said no to the Law Society. You had Ontario that said yes to the Law Society. Then you have a five-member bench in BC that said yes to Trinity Western. So again, quite a diverse engagement. But I think the disappointment, it's one at the denial, but also given all the work that went into it, it's be devastating for Trinity Western and those who've been fans of Trinity Western and hoping for the law school. On the underneath it all is then looking at a decision that was crafted with a certain fact situation in mind, and then that's where you start saying, okay, what are the implications going forward? And that's why I started off saying there's a context here. There's some other recent decisions involving religious freedom that we need to interpret this decision in light of those, and to Haag decision and the Wall decision. And also just, looking carefully at what are the implications and what does this mean for institutions that have covenants, that have statements of faith, that are trying to be missional, to be as open as possible, but maintain their integrity. So the landscape's changed a bit. Some of the rules, some of the guideposts have changed, but we're still called to engage and be faithful witnesses. And so that's our task before us.
Justin, are other Czech schools worried? Are you hearing from them?
Yeah, I think one of the main questions is community standards. Are our community standards appropriate? Do they need to be reframed? And that's the main thing that I've been hearing, less so on the area of professional accreditation, funding, and the like.
There has been some talk and speculation that Trinity Western might decide to remove that covenant or change it. I'm curious about your response to that, and maybe you could start, Alberto. Would that be a loss? Would that be a concession that they don't want to make?
Well, yeah, as it stands, if Trinity Western wants to pursue a law school, that's the only way they can do it, is if they either abandon the community covenant, make it not necessary for the law students, or make it voluntary. I don't know if they're going to do that. I don't know what they're thinking about. I'm sure these are discussions that are happening around the table at Trinity Western right now, because they're existential discussions. If they do abandon the community covenant, no doubt some will see it as a confirmation that this was not integral to the Christian faith or their Christian character and identity. Some may say it was all for nothing. I mean, I don't know where I stand on that. But if we put ourselves in Trinity Western's shoes, this really is an existential crisis for them, because, as Justin pointed out, their teachers' college might be next, and then their nursing school might be next. And so I suspect that Trinity Western and all of the faith-based educational institutions are having that discussion right now, because it really will affect how and if they get to continue to operate. Yeah, I think the only caveat to that would be those closed or covenantal institutions where there is a statement of faith that you must adhere to in order to attend. I think they're still safe, and I think they're still protected. But those schools like Trinity Western, where you don't need to be a Christian or a particular type of Christian to attend, this is obviously a very real issue for them. So
yeah. Okay, thank you. This is a question that we received on social media this week. Is this decision a continuation of a trend against Christian institutions? Bruce, do you want to tackle that one?
I guess it's, I'm trying to, in terms of a trend, again, I just mentioned a few weeks prior to this decision, we had the Wall decision, which is 9-0. It wasn't even based on the charter, but it was a strong affirmation that courts don't have the, and Albertas argued in that case, courts do not have the competence or the jurisdiction to weigh into internal membership decisions of religious organizations. So a very clear, that affirmed what has been kind of historically accepted, but again, 9-0. And so they said basically the courts are limited. There are places that courts should not go. And so we have that that side. So yeah, there are the decisions need to be read in context and again and kind of read together. But also, I think the other side of it is that evangelicalism and evangelical institutions. I mean, we're out there, and that's part of our who we are. We want to engage with others. We want to care for others. We want to serve others. We don't want to serve just our own, but we want to serve people of other faiths. That's part of our ethos, and hence we're it's the evangelical community that have the liberal arts colleges. Right. And it's an evangelical institution that decided to have a law school. Hey, why not? Right. We have the capacity. We have there's support within the evangelical community to fund and support it. Again, the Federation Law Society's other group said, yeah, you'd be able to do this. You could probably do it well. And so there's few other religious communities in Canada that are actually engaging that way in terms of whether it's inner city missions or whether it's educational institutions, camps, a whole array. I mean, that's where the Canada Summer Jobs has been kind of interesting, is that the media have now picked up on the number of types of activities that churches and missions and camps engage in that serve others and benefit the public interest and benefit the public good, yet are driven by evangelicals. So another way to look at it is that, well, I'm certainly aware of the ramifications and the unintended or intended consequences of perhaps these decisions could be. On the other hand, it's the evangelical entities that are out there and ministering. And so we're going to be facing the challenges first. Yeah, and often we're facing the challenges on behalf of other faith communities that may follow us.
Yeah, very entrepreneurial and risk-taking, right? Which opens us up to these sorts of things. Question from a viewer. We'll give this to you, Alberto. Looking back, is there something we could have done to have prevented this outcome? I'm sure you and your fellow lawyers have been thinking about that.
There are probably 1,000 things we could have done to prevent this outcome. But realistically, I started out by saying this is a very technical decision and a very specific decision to these facts and this legislation. But frankly, my feeling is the court would have ended up in this direction, even under a different set of facts. Maybe. I mean, that's obviously speculation, but that we could have ended up there. What's interesting is, as Bruce said, this is kind of a one-off. Your earlier question was, is this a long line of attacks on institutional religious freedom? In fact, it's actually not. Over the last decade, the law has been going in the other direction, in fact, affirming institutional religious freedom. Right now, the law is on a path and on a course towards recognizing that an institution, a corporation, an entity may, in certain circumstances, benefit from religious freedom. So this is kind of a one-off. Is there something we could have done differently? That's the million-dollar question. That's the question all the lawyers involved have been asking themselves for the last 10 days and will ask themselves for the last 10 years. I think the only thing that could have potentially been impacted the outcome was if there was evidence to show that studying law in this kind of a Christian environment, which is fostered by the community covenant, was necessary and integral to the practicing of one's faith as an evangelical Christian. I don't think that's accurate, so that's why we didn't do that.
Yeah.
But I think if we had that kind of evidence, it might have changed. It might have impacted the outcome.
Yeah.
Can I jump in there?
Sure.
Yeah, I think that's a critical point. And the majority were very clear that when they're looking at the Section 2A, the religious freedom guarantee in the charter, they're applying it to what they call the Trinity Western University community. And in their decision, they focused on law students. So the question was, a Christian law school, is it essential to their faith that they study law at a Christian university? And the answer was no, that it was a preference. It would benefit them. They would appreciate it. It would enhance their faith, but was it essential? The answer was no. And that's where the minority kind of, they also use the test of Trinity Western community, in other words, law students. And again, all four, three of them in the McLaughlin in a concurring opinion, and then the two dissenters thought that should be much more robust. In terms of the infringement of religious freedom, but they too were focused on Trinity Western community. Another question is that Trinity Western itself as an institution, does it have religious freedom? Because then you're in a situation of Trinity Western saying, well, yeah, it's necessary for us to fulfill our religious mandate to have a covenant. And who knows what the court would have done there, because then actually one of the concurring opinions by Justice Rao kind of drove a wedge between that and said, well, you know, this religious practice of having a law school is not necessary to the students, and actually religious freedom doesn't even apply because it's not a core religious practice. So I kind of wonder what would happen if we had a more robust conclusion from the court about corporate religious freedom, whether a corporate entity has religious freedom, and then the question of whether it's necessary would be the issue of Trinity Western saying no. To pursue our mandate, it's necessary for us to have a community covenant, and then it would be interesting to see how the judges. And I wonder whether the five, and the majority would have been held together if they went down the road of asking the question about corporate religious freedom, because there you have some on that majority who had gone different ways.
Okay. Another viewer, thank you, has asked about this balancing of rights that we talk about a lot. So, and this idea that while there's no hierarchy of charter rights, certain rights have become more central for the Supreme Court. Do you guys agree with that, Alberto? I think you're muted.
I was muted. Thank you.
We've all done it. We've all done it.
Can you just repeat that last part?
Yeah, this idea of the hierarchy of charter rights. Right. Apparently, a former justice had commented that while there is no hierarchy of charter rights, certain rights have become more central. And I'm just wondering what you think of that.
Well, I mean, it's hard to comment on that. I don't think this case creates a hierarchy of rights. All along throughout the litigation over the years, Trinity Western's position and our position on behalf of the EFC in Czech was there are no conflicting rights here. So we've seen most of the religious freedom case law in recent years has been the result of a clash of charter rights or a conflict of charter rights. My freedom of religion versus your freedom of expression or picket or equality rights. And the argument was that's not the case here. And in fact, the court didn't say that. What was very interesting is that nowhere in the decision does the court suggest there were competing rights here. There were competing interests, there were competing values, but there were no competing rights. So is there a hierarchy of rights? No, not from a strictly legal perspective. In a practical sense, is there? Well, I mean, certainly there may be, but there should not be.
Okay, thank you. Justin, we've received a question. Do you think it matters that the covenant about faith was optional, but the covenant about behavior was required? Presumably you have a grasp on all the different types of covenants and standards with the schools. Do you think that was a factor?
Well, I think Bruce has already addressed that. And I think, yes, I think schools that have adherence to a faith statement as well as a religiously based behavior community standard statement are better positioned. I think you open up a different set of dynamics when you have open admission. That being said, I'd like to hear reactions from my colleagues about the idea that there are other options between simply a mandatory covenant or a voluntary covenant. And that is to say, if there are community standards, I think there are schools right now that are practicing something where students acknowledge the standards. The standards do foster a campus ethos, protect the religious identity, but individual infractions are dealt with, as Bob Kuhn said, pastorally, restoratively, not punitively. And so in that sense, standards are acknowledged. Are they mandatory? No, there are students that break them that the institution works with.
Okay.
Is that a different model?
Thank you. So a lot of discussion is going to be taking place in a lot of schools.
Definitely.
Yeah.
Yes.
We're getting lots of questions about the impact on the local church. People are concerned about churches that have marriage between one woman and one man as a stated doctrine, and this possibility of the loss of charitable status, which I think the Canada Summer Jobs attestation situation also added to that fear. So Bruce, do you want to tackle that one about impact on the local church and what we can be thinking about?
Sure. In terms of charitable status, it was raised actually by the Canadian Bar Association when they were arguing in favor of the law societies against Trinity Western, that they thought, the withholding of accreditation because of a covenant by kind of some entity with statutory authority, in other words, something that's given, government has given jurisdiction in a certain area, can they withhold accreditation or a public benefit if they don't like the activities of the entity? And they thought that was kind of a natural outcome. Supreme Court didn't go there. They didn't even mention it at all. And I think actually in terms of charitable status, it's the Canada Summer Jobs kind of approach, where you need to affirm certain things before you get some type of benefit or government grant that is, I think, more of a direct threat at that level. But again, no one's raised charitable status except for the Bar Association. And so in terms of local church, again, this is not about marriage. This is, there's, we still have, and the dissent mentioned it, there's still the Section 3 of the Civil Marriage Act, which says that, your view of marriage should not prohibit you from receiving federal government benefit or protection. We still have the Supreme Court reference in marriage, which they basically said they couldn't conceive a situation where a clergy or a place of worship would be compelled to marry someone contrary to their beliefs. And so I don't think that's not this. I think right now the broader context of the Canada Summer Jobs, and again the idea is when's it appropriate to withhold accreditation, that is more affects us as churches or ministry organizations when we're accessing government benefits or requiring government accreditation. I think that's where things are kind of swirling around now. We'll need to decide, for me, it comes down to pluralism and to what it means to have a neutral state. And the dissent really makes this clear. In a robust society of deep pluralism, are we going to allow entities shaped by those deep religious differences to be engaged in the public square? And that's where the dissent sent up a strong warning, said the implications or the kind of the direction, the subtle directions of the majority decision are implying that the state's no longer, in a sense, sectarian or non-sectarian, where it doesn't play favorites, but it's becoming a little more ideological. And it's doing that through the guise of charter values. So it's right. Creating charter values as a way to interpret the rights and freedoms and apply it. So I think that's the direct challenge that we're facing.
Yeah. So a follow-up question to that from a viewer: what can or should churches be doing now in response to this decision, and how can churches support the EFC and other organizations on this and other issues? So should churches be doing anything differently now, or just carry on? Bruce?
Oh, I was going to let Alberto answer that first.
No, I've got a really big one for him next. So
okay. We need to, there's been a series of challenges now. The Canada Summer Jobs have been launched, judicial reviews. Albertos was involved in one yesterday, dealing a group of businesses. And so that will work its way through the courts. So we'll test the idea of the attestation, whether that is indeed, as we see it, a violation of religious freedom and conscience, being required required to attest to a certain set of values in order to access a government program, government benefit. So I think that will be more telling for us going forward than Trinity Western itself.
Okay, thank you.
If I
Alberto?
can just add,
Please.
one thing on that.
Yep.
The question was, what should churches be doing? Well, there's two, and one from a organizational perspective, two, to support the EFC. One, support the EFC because they're boots on the ground. Two, you got to look at your policies. If you don't have any, you've got to develop some. And if you do have some, the law changed 10 days ago, so you need to review them. That'll apply less to churches, which are closed, and you have to have a statement of faith and agree to certain doctrinal positions to be a member. But if your church operates programs, or if you're a religious organization that is not a church, you really need to be looking at this, because the whole world, I'm reluctant to say it's the end of religious freedom in Canada, because I really don't believe that it is. But I also don't want to belittle the implications. The law changed and the world changed last Friday,
so
right?
Tell us what a church should look at in terms of their policy then.
In terms of membership and staffing, the Trinity Western decision likely has zero impact on your policies and your rights and your obligations. But if you operate programs outside of the parish or the congregation and outside of your Sunday church service, you may basically, if you're operating a program or doing anything that is open to the public beyond your church service, you may need to be looking at how, if at all, this decision and the implications it has on human rights law will affect you. So I mean, it's very specific, but call the EFC for resources, call your lawyer, and do that analysis.
This is for you, Alberto. A question came in about an hour before we began. Doesn't this decision open the door or soften the ground to the eventual removal of the religious defense in the criminal code hate speech offenses?
I'm not sure about that. In fact, I'm not quite sure what the reference is.
Go ahead.
So if I'm understanding correctly, the question is, how does, in the criminal code, if you commit a crime against somebody on the basis of their religion, that is considered a hate crime? I think that's what this person might be referring to. I don't think it affects that at all. But I might have misunderstood the question.
No, that's how I would have read it as well. So thank you. Justin, the Supreme Court, the question is, did they have any trouble with any other parts of the community covenant, Trinity Western's community covenant? And they say it seems like a very robust document. Of course, it talks about more than just marriage between a man and a woman. Was that just what this was about, do you think?
My understanding is that's precisely what it's about. But they didn't question having a covenant. They really didn't zero in on any other part of it. It really came down to this potential harm that the marriage clause could cause certain people.
Okay, Alberto, back to you. Is it time to take a strategy of avoiding litigation? For instance, with the pending education cases in Alberta, we could instead wait for the NDP to be removed in order to avoid bad precedent. What do you think of that?
Well, I mean, I put food on my table by engaging in litigation, so I think that's a terrible idea and a terrible suggestion. No, I don't think it is. In fact, I think this should be a call to arms. I know that sounds militant, and I don't mean it to sound militant, but look, I'm in my 30s. I blame old people for the state of the law in Canada. And I say that in jest, but I do believe it as well. I think for the last 30 or 40 years as a community, we have taken the approach that we should not engage in fights. We should not engage in litigation. Let's compromise. We're in the world. We're not of the world. So you can do what you want. Just don't bring us with you. And I think that attitude has got us to a place where we're now responding and playing catch up. Whereas, the proverbial other side, not that there's necessarily a big bad guy on the other side, but the proverbial other side has been active in advancing their policy goals or agenda, or, I'm trying not to sound conspiratorial, but they've been advancing their interests. So I think, in fact, we should be doing the exact opposite and being, Bruce earlier said we have to continue to be faithful. And I think we have to do that. And part of being faithful, I think, is not only saying what we believe and living in accordance to what we believe, but defending what we believe and our right to do that. I mean, Paul used the law. I often joke about Jesus flipping tables in the temple. We need to start flipping tables. And if you look at the big cultural changes in Canada over the last 30 years or so, marijuana will be the sole exception to what I'm about to say. Most of them, or all of them rather, have occurred through litigation, not legislation. And I think of abortion in the 80s. I think of same-sex marriage in the early 2000s. I think of prostitution. I think of euthanasia. Marijuana is the exception. And of course, there was a lot of litigation on marijuana that sort of paved the way to where we are. So all of these cultural battles, if you want to call them that, have been lost or won through the courts. And we probably need to start considering that as well. So, as lawyers do, long-winded way of saying, no, I don't think we should be avoiding litigation, but at the same time, we got to be engaging in strategic litigation. That doesn't mean we fight every case. That means we fight the best case.
Yeah.
If I can,
please go ahead, Bruce.
Yeah, but also it's I agree with Alberto. So we need to engage, and the UFC has been engaged for a long time. We'll continue to, and there's now more others engaged in interventions and legal action now than there was 15, 20 years ago. But also, it's really important that we read carefully what the decisions have said. For example, the Canada Summer Jobs issue raised the conversation about what actually the Supreme Court said on the issue of abortion. And the Supreme Court has never said there's actually a positive right to abortion. In the marriage reference, the court actually ducked the question about whether the Constitution requires us to redefine marriage. They didn't answer that question. Euthanasia, I would argue the Carter decision, it never said that there's a constitutional right to euthanasia. They said that in certain circumstances it should be decriminalized. And so unlike some of the parallel cases in the US, in Canada, the courts have actually, they've, I agree, they paved the way to significant cultural change. But often when you read the decisions, they didn't go as far as many people thought they did or argued that they did. And they kind of step back. So again, in a sense, the Supreme Court did not, I understand the serious nature of the decision and the blow it was, but they actually didn't say Trinity Western could not have a law school. They said the Law Society's decision not to accredit was a reasonable one. And so we need to keep that in context and take these decisions going forward and argue, make the arguments we need to make and continue to engage, but also understand what the courts actually did say and didn't say.
Yeah.
Yeah, if I can just build on that for just one quick moment, Bruce is absolutely correct. And when the court said that the Law Society's decisions were reasonable, they actually explained what reasonable is a lay term, but in this context, it was used as a legal term. And the court describes what a reasonable decision is. And they, in fact, say there may be multiple different decisions that could be reasonable. A reasonable decision is one that falls within the range of reasonable possibilities. So what does that mean theoretically and practically? That means that the 9 other provinces in Canada who did approve and accredit Trinity Western's decision, application to run a law school, those decisions were reasonable as well. So that's why Justin, Bruce, and I keep saying this is a very specific decision, and it's not this overriding precedent that some people are making it out to be.
I have found myself wondering if the Canada Summer Jobs attestation situation was actually more alarming. And I don't know, maybe we don't compare these things in that way, but am I wrong? Am I crazy? Bruce?
Well, I don't.
No, I don't think you're crazy. I see it. We'll see how the courts interpret it. But again, this was, as Alberto said, rarely it's the government taking the initiative. It's normally actions through the court. And here you had a government that's actually requiring expression of a certain set of values in order to attain a government benefit. And those values had nothing to do with the actually tasks that the money was flowing for. And so to me, that's a difference. It's almost like Trinity Western in reverse. It's on its head. So it's a government actor setting up, in a sense, a covenant and requiring that you adhere to this covenant to receive a benefit. So I see it is much more immediate concern than the Trinity Western decision. Even though there are underlying it, there are issues at play that are very concerning, like the issue of charter values and again, whether it's appropriate, when a government provides benefit to an organization, whether that means it's actually merely providing support to an objective that the government agrees is the public good, or whether it's condoning the overall organizational enterprise and its beliefs. Those kind of issues I think are concerning. But I see Canada Summer Jobs as much more concerning directly than Trinity Western.
Yeah, and if I can just build on that, this wasn't a law that was passed. This is some kind of administrative regulation, and those are much easier to put in place. And so I think it's alarming for those reasons as well.
Okay. Alberto?
Yeah, I mean, I'm just going to agree with Bruce and Justin. I don't think you're crazy, Karen, and I do think that these are related. And like Bruce, I agree that this might be more concerning, right? So Trinity Western showed up and applied for a law school, and I think they should have been approved, and like they were in most of the country. But there are a lot of other factors that must be met before you even get to apply for a law school. The Canada Summer Jobs is meant to be an open program available to all businesses, for-profit, non-profit, political, apolitical, so long as you didn't have so many employees. So it's supposed to be much broader and much more appropriate. And the implications, I think, of the Canada Summer Jobs attestation requirement is that if it's okay, if the courts say that it's appropriate and okay for the government to require an organization to adhere to a certain political, moral, social, ethical, and religious view, in order to qualify, you're not even guaranteed to get the grant by checking the box, but you need to check the box in order to qualify. If that's appropriate, why is it then inappropriate for the same government to say you must check this box or that box before you even qualify for applying for charitable tax status? So yeah. I agree with you that it's much more alarming, but because it's much more alarming, it's also much more vulnerable to attack.
Right. Okay. We've had a couple of questions come in about homeschooling and pending cases in Alberta. So are homeschoolers, should they be worried about the Trinity Western decision? Alberto?
I mean, I'm not quite sure how, unless the governments pass legislation prohibiting homeschooling in those provinces. I don't see how this would affect that decision. If a government did decide to pass such legislation, then there may be some implications of the Trinity Western in any given challenge. And I think what would come is whether the family or families that challenge such legislation have a sincerely held religious belief that they must educate their children in a home setting. So I'm extrapolating a lot here, which might suggest that no, there should be no immediate implication.
Okay, Justin?
Yeah, and if I can jump in on that, I think probably the link again to the Canada Summer Grants attestation is one that's closer. In other words, and I'm here thinking, first of all, of K-12 Christian education in 5 provinces. It does receive some kind of public funding. And again, there's nothing preventing those governments from at some point making curricular requirements. For example, the sex ed curriculum in Alberta that needs to be adhered to, otherwise the funding would in some way be jeopardized. But I think that is a different situation than homeschoolers because they're, I think, regulated in a much more indirect way, have a lot more freedom, and I don't think need to be concerned, certainly by the Trinity Western decision.
Okay, thank you. Another question from a viewer. Did the Supreme Court comment on the claim made during this case that having Trinity Western faculty sign a statement of faith jeopardizes their academic freedom? Did that come up in the decision at all?
Not at all. Not at all. So the real immediate implications for, say, Christian educational institutions is if you are an open educational institution where you don't need to sign a statement of faith to attend, this decision has very real implications on you with respect to the student body. If you're a closed school, it likely doesn't. In neither of those cases does this affect the ability to hire people who adhere to a certain statement of faith. Because although Trinity Western didn't require you to sign a statement of faith to study there, they did require you to sign a statement of faith to teach there.
Okay. This next question is pretty legal specific in my view, but I'll ask you, Alberto. It's about the Ontario. In light of the Trinity judgment, what is the likelihood of Ontario lawyers losing the lawsuit that will ensue after their license is suspended, revoked for failure to sign the statement of principle? I know a lot of us won't know what we're talking about here, but
Sure.
if you could answer that question.
Sure. Well, I'll give a sort of a 30-second backgrounder on that. So every year, lawyers in Ontario have to fill out an annual report. It's very basic, benign, and boring. This is how much study time I did. This is how much pro bono I did. Percentage of my practice for corporate law, real estate, and on and on. Questions about trust funds and so on. And this year, the Law Society added a new requirement, which was every lawyer filling out the annual report is required to check a box. So sounds familiar. Check a box confirming that they have a personal statement of principles, which affirms and recognizes their obligation to promote diversity, equity, and inclusion. Now, on its face, there's nothing wrong with that because diversity, equity, and inclusion are good things. But many lawyers were upset about that because there's no obligation in law to promote any ideology, let alone an ideology that you may agree with. And there's also a lot of concern because the same Law Society thought that Trinity Western was not equal, not inclusive, and not appropriate. So how are they defining those terms? So I, for example, did not check the box, and a bunch of other lawyers did not. And so we may face discipline, and ultimately we may face losing our license for doing that. And the question was in reference to a legal challenge brought saying that that is unconstitutional. So how does the Trinity Western decision affect that? I think it actually might help because a lot of the decision centers around this public interest mandate that the Law Society had, which they interpreted to include or to mean ensuring equal access to the profession. And the court found that the community covenant acted as a barrier, or rather the court found that the Law Society's conclusion that the community covenant acted as a barrier to the entry to the practice of law on the basis of immutable characteristics unrelated to skill and competence, that was an appropriate interpretation of their statutory mandate to protect the public interest, which in simple terms means barriers to access to the practice of law and immutable characteristics unrelated to skill and competence is against the public interest. So if this case can now suggest that a person's moral view or conscience or religious view or freedom of expression prohibits them or precludes them from making that attestation or having that statement of principles, they could argue that this is contrary to the public interest because it acts as a barrier to the entry to the practice of law on the basis of immutable characteristics unrelated to competence and skill. So it doesn't always work that way where you take language from one case and use it in yours, but if the courts want to be consistent, and in fact, if the Law Society wants to be consistent, I don't see how they can continue to push that statement of principles.
Wow, so that'll be an interesting case to watch.
Yeah.
Bruce, let's start with you. I'm wondering right now, in terms of the big bird's eye view picture here, what is the best thing the Christian community in Canada can be doing right now? And what would be the worst thing?
The worst thing would be to withdraw.
Okay.
And become insular. The best thing is to continue to engage, to, love God by loving our neighbor, engage fully and be fully present within our society as Christian, but realize, as Albertos put it, that the landscape has changed, and there's different expectations, and our freedoms and rights are being interpreted differently than they had before, and so we need to be kind of a situational awareness, I guess. Be aware of the context. Double down on look at your mission, your mandate, what you're trying to accomplish, and consult a good lawyer, and make sure you're dutiful in terms of that dimension of life, but don't let that dimension of life inhibit you from doing what God has called us to be and to do.
Justin, what's your answer to that question? The best and the worst thing the Christian community could be doing now?
I think the worst thing would be to be striking back with very strident and unbalanced kinds of arguments and claims. I think those can undermine our case. I think the best thing that the Christian community can be doing would be, first of all, and I mean this sincerely, steadfast prayer, because at bottom this is a spiritual battle. And the word teaches us that our primary weapon is not words, it is prayer. It's to do spiritual warfare. And so I really, this is not a landmark thing legally, but I hope it's going to be a decisive hinge for the Christian community in Canada to really call us together to say, let's wake up. We have stories to share. We have institutions, as Bruce has said, that contribute to the public good. Let's celebrate that. Let's do more of that. Let's engage the public square with the witness that we have and use the freedom that we have in this land.
Thank you. Alberto?
Yeah, I agree with all of that. I think withdrawal from these battles, battle is perhaps a strong word, sort of got us to where we are. So that would be a terrible thing. We got to walk into the table and flip a table. Walk into the temple and flip a table. We just got to be strategic about which temples and which tables we walk into and flip.
So
and what I heard Bruce and Justin say is I'm the best lawyer and they should call me.
I was going to wrap up, but I don't know if we should end on that note. But I will end by saying thank you, Bruce, thank you, Alberto, thank you, Justin. I think you've helped us set this in context and understand more what's going on and what we can watch for in the days to come. And thank you most of all to the people who joined us and sent in such fabulous questions. They really helped. So thank you for that. This webinar is going to be posted online on our website, the efc.ca/webinars. That will happen imminently, so you can share it with people who are unable to join us today. And yeah, thank you so much.